Okay, so my name is Professor Christine Parker. I'm the Associate Dean for Research of the Melbourne Law School, and I'll be hosting for this evening, my great delight, and I'd like to welcome you all here. I'll start by acknowledging that we are on the land of the Wurundjeri people of the Kulin Nation here, and that land was never ceded, and I want to acknowledge the ongoing work of recognition and justice that we need to do and we have committed to do at Melbourne Law School and the University of Melbourne, and of course that we need to do more broadly in Australia and around the world for First Nations people everywhere. I'm delighted to be hosting this lecture this evening for the Ninian Stephen Law Program, sponsored by the Menzies Foundation. I'll be inviting Justice David Goddard to come up and speak in a moment. But of course, first, I need to do the honours and let you know how marvellous he is and what a treat you've got in store for you, and introduce you to the topic. So Justice Goddard is visiting with us from New Zealand. He is a judge of the High Court and Court of Appeal in New Zealand, and he's just spent a week with us teaching in our master's program, a subject called Designing Effective Legislation. I believe maybe there might be one or two of his students here who are probably primed with questions. Justice Goddard is a mathematics graduate before he saw the light and went to Oxford to study law as a Rhodes Scholar. He then went on to a career in academia in the UK at Bristol University before returning to New Zealand to practice as a lawyer. He was just telling me that he did intend to come back to academia at some point, but that was about 30 years ago. And I was saying that often I know some of our students who are graduating tell me they're just going to go practice for a couple of years, then they'll come back and do a PhD. And sometimes it happens and sometimes it doesn't. Anyway, you're doing everything all at once, it seems. Justice Goddard was appointed Queen's Counsel in 2003. He has also been very involved in drafting, including at the international level. And I'll just read you some of the things that some of his experiences. Justice Goddard was a member of the Commonwealth Secretariat Arbitral Tribunal and acting president of the tribunal. And that was between 2011 and 2019. He's been extensively involved in law reform in New Zealand and overseas, advising ministers and government agencies and representing New Zealand in bilateral and multilateral negotiations. He was chair of the diplomatic session of the Hague Conference on Private International Law that adopted the Hague Convention on Recognition and Enforcement of Foreign Judgments in civil and commercial matters in 2019, and he was vice president of the diplomatic session that adopted the Hague Convention on Choice of Court Agreements in 2003 and a member of the drafting committee for that treaty. He's also undertaken research at New York University. He told me he taught previously at Monash University, so as you can see, he's had an illustrious career in all the fields of law, and he will be speaking with us tonight. You see the title of the lecture there, The Perennial Problem of Complexity, and it relates to his recent book, drawing on his experience, Making Laws That Work, How Laws Fail and How We Can Do Better. Please welcome Justice Goddard.
Good evening, everyone. Christine, thank you for that very kind introduction. It's such a pleasure to be in Melbourne. I've had a wonderful week teaching on the master's program with a group of very impressive students from all around the Asia Pacific region. I've learned a lot. I hope they've learned something. It's everything I hoped academia would be, despite my slightly absent-minded approach to returning to it, Christine, which took longer than initially planned. So what I'm going to talk about tonight is one aspect of the research that I did at NYU when I was working on my book on legislative design. And I'll talk a bit about the starting point of that in a moment. But what I want to talk about tonight, because it's so topical in Australia, is the perennial problem of complexity in written laws. It's attracted a lot of attention here recently, and for good reason. If you want to find a jurisdiction rich in examples of complex laws, Australia is a good place to look. So let's begin with a brief and very selective history of complaints about complex laws. I should say that I've been told I need to stay still. I find this quite difficult, but I'll do my best. I tend to like to move around. Anyway, back to the history of complex laws. So the history of written laws can be traced back around 4,000 years. There's a wonderful book about the history of written laws by Professor Fernanda Pieri, a professor of legal anthropology at the University of Oxford, which traces written laws back through a number of traditions to about 4,000 years ago. And for much of that 4,000 years, people have been complaining about the complexity of those laws. There's at least 2,000 years of recorded complaints about complex laws, and I reckon the oral grumbling goes back further. But of course, it's no trace left of that. That's just an educated guess. So in 1550, and one of my favourite quotes on this, King Edward VI wrote a letter to his assembled Parliament, set out the specific things that he wanted Parliament to deal with in that session, and then turned to this: devising of good laws. I've showed mine opinion heretofore what statutes I think most necessary to be enacted this sessions. Nevertheless, he said, I would wish that beside them hereafter, when time shall serve. Notice that the whole process of bringing coherence to the statute book comes after the immediate political priorities. That hasn't changed, as any policy advisor, any drafter will tell you today. I would wish that when time shall serve, the superfluous and tedious statutes were brought into one sum together and made more plain and short, to the intent that men might the better understand them, which thing shall much help to advance the profit of the Commonwealth. And those complaints continued. I should say actually they began much earlier than that. An emperor of the Han dynasty complained in the 1st century of the Common Era about the vexatiously numerous laws and the prolix legal system of China at that time. In the late Roman Republic, Cicero criticized jurists and their opinions for being convoluted, and of course the great Roman codes of the 5th and 6th centuries were attempts to rationalize the complex edifice of the then current Roman law. Similar concerns turned up early in the history of the United States in the 18th century. After independence, several revisers were appointed to review the legislation inherited from Great Britain, from England and Wales, and the legislation passed by the states to determine what should be retained and how it might be improved. Thomas Jefferson was one of those revisers. Imagine being appointed to review the whole of the statute book. Quite a big job, right? But quite fun. He was one of the revisers appointed to review pre-independence British and American legislation to select the laws that should be reenacted by the new Union. And in his autobiography, he referred to the need to reform the style of the later British statutes and of our own Acts of Assembly, which from their verbosity, their endless tautologies, their involutions of case within case and parenthesis within parenthesis, their multiplied efforts at certainty by seds and aforesaids, by ors and ands to make them more plain, do really render them more perplexed and incomprehensible, not only to common readers, but to the lawyers themselves. At around the same time, Federalist Paper 62, which was probably written by James Madison, although those of you who have seen the musical will know that Alexander Hamilton wrote at least 51, probably written by James Madison, identified complexity of laws as a hindrance to effective democracy. He said it will be of little avail to the people that the laws are made by men of their own choice if the laws be so voluminous that they cannot be read, or so incoherent that they cannot be understood, if they be repealed or revised before they are promulgated, or undergo such incessant changes that no man who knows what the law is today can guess what it will be tomorrow. Law is defined to be a rule of action, whoever it was wrote, but how can that be a rule which is little known and less fixed? Coming forward to the present day, of course, we have the Australian Law Reform Commission's inquiry into Australian financial services legislation. The report was entitled Confronting Complexity, nice alliteration. And the ALRC said the legislative framework for corporations and financial services regulations no longer fit for purpose. The existing legislative framework's unnecessarily complex, and complexity only continues to accrue. Parts of the legislative framework have variously been described as. Now, each of these descriptions comes from a reported case. There are footnotes to the, I must say, more colourful language that Australian judges use than their more pallid New Zealand counterparts. It makes us seem a little boring when you read it. Anyway, parts have been described as porridge, obscure and convoluted, shrouded in obfuscation, I like that one, and likened to a maze. Further on in the report, we read that there's an incoherent legislative hierarchy, and that's certainly borne out by the examples provided by the Commission. And this great phrase, anything could be anywhere, meaning users of the legislation need to look everywhere. I think this brief and highly selective survey bears out Fernanda Paire's observation that complexity and obscurity are recurrent problems in developed legal systems. Emperors, kings, and ardent republicans alike have been complaining about complex laws for at least 2,000 years. What have these complaints tended to focus on? Well, there are some common themes. The first is the sheer quantity of written law, because the more law there is, the harder it is to know whether there's relevant law on a particular topic, how to find that law, and how to be sure that one has found it all. From around 930 in the Common Era, Iceland had an office holder known as the law speaker, who was required to recite the island's laws at each annual assembly of citizens, the Alting. Each of the laws had to be recited at least once every 3 years so that ordinary people could hear and remember them. Drawing on such residual mathematical skills as I have, which are mostly confined to simple calculation, I sat down to try to work out how long it might take the hapless modern New Zealand law speaker to work their way through even just our primary legislation. I reckon that even if they confined themselves to the primary legislation, it would take more than 4,500 hours, that's about 200 days, assuming 24/7 law speaking, to declaim the approximately 95,700 pages of New Zealand public acts. And no one knows it all by heart, despite spending quite a few decades working with a wide range of areas of law. I still quite often encounter statutes in my own country I've never previously come across and would not have imagined might exist. And there's been a striking increase in the volume of written law in many jurisdictions over the last 20 years, and some quite interesting empirical work has been done on that. Second complaint that you get, and this comes through very strongly in the ALRC's report, is a lack of coherent structure and hierarchy of provisions. It's very hard to find your way around the statute book as a whole, and even particular statutes. And I think, and so speaking of financial services legislation, the ALRC said that provisions are inconsistently and unpredictably located in primary legislation, delegated legislation, or administrative instruments. And that's why, because anything could be anywhere, users have to look everywhere. Then the next problem, the next complaint you get is complex linkages between provisions. You start reading something, there's a defined term, you pop off to the definitions, which may be in that part, which may send you off to definitions at the front of the Act, which may refer you to a provision in that Act, or if you're really lucky, to another Act altogether. It means, something as defined for the purposes of this other Act, and you go and read that and find that that itself has defined terms in it. You can spend quite a lot of time trying to chase down the tree of definitions that ultimately, if you're very lucky and can hold it all in your head, takes you to what was meant. So complex linkages between provisions, because all too often one provision can't be understood without reading other provisions in the same instrument or elsewhere. Even more problematically, of course, many of those linkages are not explicit. For example, where the meaning of a term can only be understood by reading other provisions in the same instrument or in another instrument. And that's why you forever find yourself saying as a judge, well, I think we need to read the whole of the Act, to counsel, why don't we go to such and such a part and look at that. One of my pet hates is the tendency to give you little chunks of a statute in a bundle of authorities, expecting that you will read the provision in isolation from its context. That's not what the interpretation legislation in Australia or New Zealand requires. It's not what we teach our students in introduction to legal system classes. Why are people still doing it in the Court of Appeal? But of course, the fact that you need to read them as a whole does make reading legislation more complex. Complexity of structure and language within provisions. I sat on a court that divided about the interpretation of some fisheries legislation recently in a difference that largely turned on the significance of some sub-paragraphing, which two of my colleagues attributed a surprising significance to. But that's been argued before the Supreme Court, and we'll find out where the ultimate numbers play out in some months' time, and who's entitled to be more surprised. Anyway, complexity of structure and language within provisions, and obscure language. Now, obscure language is less of an issue today in most jurisdictions I'm familiar with, because legislation is increasingly drafted in relatively plain English. But it does remain common for defined terms to be given artificially expanded or narrowed meanings, which can trip up unwary readers, especially as in longer statutes or statutes that have been frequently amended over time. The term will not always be used in that defined sense everywhere in the legislation. So you then find yourself spending quite a lot of time wondering whether the special meaning attributed by the definition really does apply in section 457DE, which sometimes it doesn't. So these are the complaints, and all of these are legitimate complaints. They make legislation more tedious, with or without an E, for King Edward. But why should we be concerned about this complexity? Well, I think that there are both reasons of principle and reasons of practicality to think that unnecessary complexity in legislation is a problem. First, and most fundamentally, the rule of law is undermined if requirements imposed by law are hard to find, understand, and apply. It's all very well to say the rule of law requires that laws be announced prospectively and be accessible, but if they're accessible but most people can't work out where to look for them, or if having found them, people can't understand them, then you're only complying in a very narrow and technical sense with the precepts of the rule of law, which after all is a not itself a piece of black letter legislation. It's a fundamental constitutional requirement that needs to be approached purposively if we are to have legal systems that are consistent with what we understand by the rule of law. Second, and very problematically, confidence is undermined in the lawmakers who produce the unintelligible legislation, in the officials who administer it because they do things which surprise people, and I think also in the courts that interpret it. You find yourself trying to make sense of legislation where there is a tension between purpose provisions and operative provisions, and if you run with the operative provision, people criticize you as an unimaginative black letter lawyer who doesn't understand the importance of purposive interpretation. If, on the other hand, you emphasize the purpose, then you're a liberal activist who doesn't understand that text is an important guide for citizens. It's very hard to win that particular game when you have complex legislation that doesn't point coherently in one direction. And then there are the practical issues. Complex legislation is more burdensome and costly for people to work with. It's harder to locate and apply the relevant legal frameworks. There's a much greater risk of miscommunication between lawmakers and their audiences. Sometimes you really want to do what Parliament has asked you to do, but working out what it is that Parliament wants you to do is actually quite difficult. At least, by the time it reaches us, we can give some sort of authoritative interpretation, and for the future that might help. But think of all the people who have had to try to struggle with it before that, all the people who in good faith have tried to work out what they're expected to do and have struggled to do so, all the advisors, all the officials. And of course, that risk of communication, these tensions, all mean, and this loops back to my book, that there's a risk of laws failing to achieve their intended goals. In the book that I spent a year at NYU working on, although I didn't quite get it finished, came a little bit later, as is the way with these things, I thought, well, one of the problems with legislative design is that no one pauses to ask, how do laws fail and what can we learn from failure? Failure to achieve the policy objectives of the laws. There are many disciplines in which people do systematically study failures, think aviation, think medicine, in order not to attribute blame, which in the political space tends to be quite a popular pastime, but to learn from those failures with a view to avoiding repeating the same mistakes. So James Joyce described mistakes as the portals of discovery, right? And that's true. Perhaps less poetically, but this may be one of the few things that my mum had in common with James Joyce. She was a teacher, and she used to say to her children and to her students, you should love your mistakes because they're such great learning opportunities. And that's true. But it's much easier to love other people's mistakes than your own. And so what I set out to do in my book was to gather together an interesting collection of other people's mistakes that we could learn from with a view to avoiding repeating them in our own legal design work. And I talked about, in the book, about 4 broad types of legislative failure. The damp squib, the legislation that fails to produce the desired result. Whether the concept of a damp squib needs explanation or not tends to depend partly on age and partly on geography. It's a term well understood by those of us old enough to remember firecrackers that got damp and at Guy Fawkes when you were allowed to buy them and let them off and that didn't go bang. These are laws that don't go bang. Younger people raised on the Harry Potter books who know that squibs is a derisory term for children of wizarding families who cannot do magic, also tend to understand this. These are laws with no magic in them. They're enacted, but the world doesn't change or doesn't change much. This is perhaps, I think, the most common form of legislative failure, and it often results from complexity, which means that the people whose behaviour the legislation is meant to influence aren't aware of it, or don't understand it, or don't have the resources required to comply with or benefit from the law. Overshoots, laws that deliver what they're intended to achieve but fail to stop there. I sometimes think of this as the too much ice cream problem. I spoke online to the Commonwealth Association of Legislative Council, who were holding their conference in Jamaica a few days ago, an ungodly hour in the morning, by Zoom. They were, after my talk, going off to the beach for rum cocktails. I think the same applies, right? This is the too much rum cocktails problem. You're going to the beach to have a rum cocktail. One is a great idea, very much in the spirit of the conference. A second one might also be fun, but there is going to come a point at which, although you set out to have rum cocktails, you have had one or two too many, and you are going to regret it. A law that delivers more of something than you desired, and I give a range of examples in the book, but I'm a little conscious of time, so I won't go into those now, is not uncommon. We had a recent experience of that, for example, in New Zealand with amendments to consumer credit law. I'll give one quick example that were designed to discourage provision of unaffordable credit to consumers, but which overshot and hindered a lot of perfectly viable and appropriate lending and imposed a lot of costs on lenders and on borrowers in order to access loans. Nasty surprises, laws that achieve their intended goals but produce other unexpected and undesired results. My favorite example of this, and it's especially easy to love mistakes from hundreds of years ago, is the window tax enacted by the British Parliament in 1696. The goal was to raise revenue in what was a more progressive and more transparent way than the hearth tax it replaced. No need to get into the house and count the fireplaces. You can ride around the outside, count the windows, charge the tax. You're a wealthy person, you have a bigger house, you have more windows, you pay more tax. But the designers of this law failed to think through the incentive effects, the dynamic consequences of this legislation, which was that buildings were built with fewer windows in order to reduce ongoing tax burdens, and indeed existing windows in some buildings were bricked up. And I have pictures in my book of buildings that have bricks where, if you look at the rest of the windows and the shapes, you might think windows ought to be. And that had really significant adverse consequences as people flocked to the cities in the Industrial Revolution not long after this happened and found themselves living in tenements with very few windows, shortage of light and air, savagely attacked by Charles Dickens and his magazine Household Words, in fact in its very first issue in 1850, and ultimately said that the phrase free as air had been repealed by legislation in England, ultimately repealed, and in fact the window tax in 1851. There are many examples, but complex laws give rise to an obvious risk of unexpected and unanticipated outcomes because it's easier to get lost in a maze. Backfires, these are a type of nasty surprise, really a subset. This is a law that exacerbates the very problem at which it was aimed. This is a very special sort of policy failure. The most famous example is the Cobra effect that was the unhappy result of a policy adopted by a British governor in Delhi in the late 19th century. There was a problem with poisonous cobras in the city, too many poisonous cobras, a lot of complaints about this. The governor thought, well, I know how to deal with this. I will offer a bounty on cobra skins. So you pay a certain amount per cobra skin. Only problem was it turns out it's quite easy to breed cobras. So a whole bunch of people caught a few cobras, popped them in a pen with whatever it is that cobras like to eat, small mammals, I guess, I don't know. And they flourished and bred. You waited till they got to a certain size and had themselves had an opportunity to reproduce, and then you knocked them on the head, skinned them, claimed the bounty. So they were paying out an awful lot on the bounty, no material reduction in sightings of cobras in the city, so of course you cancel the bounty. Now if you had a pen full of cobras in your back garden that you had been raising to claim a bounty and the bounty was cancelled, what would you do with the cobras? You open the doors and release the cobras. End result? More cobras in the city, not fewer. Now you might think this is such an extraordinary example, it could only ever happen once, and there is some debate about whether this actually happened in Delhi, but there are really good recorded examples of exactly the same sort of policy playing out in Hanoi with rats in the early 20th century. I won't go into the details. Suffice to say that there were no fewer rats in Hanoi after an awful lot of money had been paid out on the bounty on rat tails. There are newspapers from the period reporting on a surprising number of sightings of tailless rats in the city. It turns out that as well as breeding them, you can actually just catch them, chop the tail off, take the bounty, but you let them go, of course, to make more rats, to make more bounty opportunity. Anyway, and in about 2007, at a military base in the United States with feral hogs, they weren't actually being bred, they were just being lured in by scattering food in the relevant area. Anyway, backfire is a particularly nasty type of failure, and adding complexity to laws can increase the risk of backfires. Now, we shouldn't be surprised by a measure of complexity in our laws. After all, the societies we live in are complex, and our laws are expected to provide the infrastructure for and regulate a wide range of social and economic issues. But in common with most commentators, I think our statute books incorporate a great deal of avoidable complexity. And I'm also confident there are steps that can be taken to reduce the complexity of those statute books despite countervailing pressures. And the recent ALRC report provides some examples of how one might go about that. But, so far I've been focusing on complexity on the page, complexity in our written laws, which is what King Edward was complaining about, what's all my other quotes complained about. Actually, I don't think that's the biggest problem. Of course, readers of legislation are an important audience, but if what we're concerned about is the rule of law implications of complexity, if what we're concerned about is the effectiveness of laws, then our focus should be on the people affected by legislation who will never read it. And that is the vast majority of people to whom legislation applies. Most people who are affected by a law will never read it themselves, will never seek legal advice on it. So, through what channels, through what interfaces will they become aware of the law? Will they become aware of the law? And how will they become aware of its implications for them? As soon as you focus on the people who are affected by the law, and I think it's difficult to overstate the importance of this change in perspective, because making law is a form of communication, after all, between a lawmaker and the various audiences for that law. But if you're writing for an audience that's never going to read the beautiful words you've written, how do you effectively communicate with them? You have to find ways of ensuring that your communication, though indirect, will nonetheless be clear, timely, and effective. So you need to pay attention, and this is really the central thesis of my book, to the institutions that will be the intermediaries through which people come to understand what the law means for them. You need to pay attention to interfaces. And if we focus on complexity as it's experienced by the user, two things, I think, quickly become apparent. The first is that King Edward didn't have it exactly right, because short is not always good. Brevity does not equate to simplicity. Think, for example, of a requirement, this is drawn from New Zealand's hazardous substances laws, to store, transport or use hazardous substances, taking all practicable steps to avoid causing harm to any person or to the environment. That's quite short, it's quite punchy, it sounds like a sensible thing to ask people to do. The only problem is that each and every person to whom you are speaking, including every farmer who has agricultural chemicals, everyone who stores fuel, many suppliers of medical services, all need to work out what this means for them in the particular context in which they need to apply it. It takes time, information, expertise, and the exercise of judgment to work out what must be done in each case. There's often scope for uncertainty and a resulting risk of undesired outcomes, either insufficient precaution and resulting harm, or excessive precaution and the associated costs. It's easy to multiply examples. There are many ways in which this kind of complexity can be reduced, but in the spirit of learning from mistakes, I thought that what I would do is share with you an example of a provision for which I was largely responsible, but when I was very, very young, which I think could be said to have been a failure, and what we did about it. Now, I was one of the two drafters who worked on the legislation that accompanied the New Zealand Law Commission's report on company law back in 1989. This happened rather faster than the Law Commission had expected for various reasons I won't go into, ministers changing reporting dates and things like that. And the result was that we received rather high-level instructions on what to draft on some topics. I was drafting a provision inspired by North American regimes for buying out minority shareholders who dissent from fundamental changes to a company. And the instruction was pretty much draft something modelled on the Canadian legislation, but with a couple of tweaks. And I read the work that had been done on this, I read some cases, I looked at the Canadian statutes, and it became very clear that it was not possible to prescribe any one basis on which a buyout price would be calculated. Everything depended on the circumstances. And so, drawing on the tests and some of the legislation and enunciated by the case law, I drafted a provision which provided for a dissenting minority that wanted to be bought out at a fair and reasonable price for their shares. And we made provision for that to go off to arbitration. Unfortunately, this very brief and untedious, I think, provision may well have been the right approach as a matter of principle. I think it still probably was. But it turned out that incorporating this broad standard in the legislation created great potential for both lawyers and expert valuers to disagree about what should be taken into account and what should be disregarded, about the method of valuation that should be applied. Do you have a minority discount? Do you have an uplift for being squeezed out? There was a surprising and, at least to me, disconcerting amount of litigation about the price to be paid for a dissenting minority's shares in particular cases. The provision proved costly and complex to apply, and I'll return below in a moment to the solution that was adopted to address this unsatisfactory outcome. But I think it'd be fair to say that it became apparent within 10 years that this had not worked as intended, that it was a bit of a failure. Conversely, and this is an example from a very nice paper written by former Chief Justice of Australia, Chief Justice French, who waxes lyrical about the challenge of defining income in your tax laws here as income according to ordinary concepts. Now that's just 5 words. It's nice and crisp and snappy, but the amount of case law to which it's given rise in Australia and actually in New Zealand as well is truly impressive. So brevity does not equate to simplicity for the ultimate audience, for your users. Conversely, length and complexity on paper do not necessarily translate into complexity for users. This is a variable speed sign on a motorway near my home in Wellington. Now, as you get onto the motorway heading north to the beach at the weekend, it's very easy to understand what this sign is telling you. You may not go more than 100 kilometres an hour. One evening, and this may reflect poorly on my idea of fun, I sat down to try to work out what the legal backing was behind the effectiveness of this variable speed sign. Well, it was a long journey. I won't weary you with it all now. Suffice to say that despite realising I should probably start in the Land Transport Act 1998, but actually not being able to find a requirement to comply with speed limits anywhere in the primary legislation, I eventually found my way through the Land Transport Road User Rule 2004, the Land Transport Rule Setting of Speed Limits 2022, the Land Transport Register of Land Transport Records Speed Limits Regulations 2022. Who knew there was a Register of Land Transport Records and a Registrar of Land Transport Records? The Land Transport Offences and Penalties Regulations 1999. And finally, I found that there was this thing also called the National Speed Limit Register, and I was able, using geographical searching, to find the record registered on that, which provided for the variable speed sign near my house, prescribed the different speeds that could be displayed on it, and the circumstances in which the speed could be moved up or down. Now, and it took me hours, which is kind of depressing, right? Because I'm supposed to know how to work with legislation. It took me ages. And my attempt to describe it in a paper I wrote about this goes on for pages, and lots of bouncing backwards and forwards between different levels of legislation. Now, I'm pretty sure that Edward VI would have found this tedious in the extreme. I certainly did. Who would have thought that understanding why I have to comply with a variable speed sign close to home would require analysis of primary legislation, two different forms of delegated legislation made by different decision makers, and an instrument created by yet another decision maker made pursuant to delegated legislation? But of course, the audience for the law, the audience on whom its effectiveness depends, is not me. It's not primarily lawyers. The ultimate audience for this legal rule is drivers on the motorway, and they are spared all this pain. I think this tangle of instruments probably could be simplified, but the reality is that it doesn't matter much. We don't need to be unduly concerned about the complexity of a legislative framework that few people will ever read and that delivers clear guidance about requirements imposed by the law to people affected as and when they need it. So, interfaces. Interfaces are critical. And I thought I'd give you a few other examples of interfaces that I've encountered in recent times. I'm doing lots of travel recently. In New Zealand, as you land, you get an oral warning about biosecurity rules. In Australia, they play you a video. And you find out that if you have an undisclosed banana in your bag, you might be subject to a spot fine of a few $100s. It's useful information to know. You can pop your banana in the bin. In Singapore, they also provide some quite important information as you're about to land on the arrival card. Death for drug traffickers under Singapore law. It's not immediately obvious to me what you're supposed to do if you have a kilo or two of meth concealed somewhere in your suitcase. I'm told that in Chicago, because in Illinois marijuana is still unlawful, unlike in a lot of other nearby states, there actually are bins for you to drop your marijuana in after receiving similar warnings. I haven't seen any, drug bins in Changi Airport. But anyway, maybe if you confessed all, some less onerous penalty might be imposed. Other interfaces that ensure that relevant legal information about somewhat complex legal regimes are provided as and when you need it. Now, this may or may not work. Let's see.
NYPD free! NYPD, keep your hands where we can see them! You have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, what will be appointed for you? Why did you stop?
I'm done. You win.
Okay, so in most systems, the law requires that someone who is arrested is provided with timely legal information about their right to remain silent and their right to legal advice. Now, I'm not advocating for providing legal information to people by having two people shout it at them at the same time. I think generally that's unhelpful. And although I haven't seen any research on the subject, I strongly suspect that pointing a gun at someone while you provide them with legal information has adverse consequences for both immediate understanding and retention. So this is not the best example of an interface, but at least in my country, those rights tend to be explained to people in a more measured and helpful way, and it's a very important example, I think, of a relevant interface. They can be multiplied indefinitely. Complexity-reducing interfaces take many forms. So what can we do about complexity experienced by users? There are many, many ways in which we can reduce the complexity of legislation as users experience it. I haven't got time to talk about all of them. What I'm going to do is provide a few more or less arbitrarily selected examples. The first is signposts. Literally, in the case of my variable speed sign, signs that say, hunting forbidden, signs that remind employees who are required by law to wash their hands in a food business before going back to work, that they're required to do so in the bathroom. Signposts are widely used to communicate contextually relevant, timely information to people about complex legal regimes. Default provisions. Default provisions are an extraordinarily important and underused tool for making broad standards more comprehensible to users. You can say, well, here is the broad standard, but normally do this thing, and depart from it by reference to the broad standard only if. And then you can decide how sticky to make that default. It can be just a suggestion. The court may order the following, which gives you some possible orders, but gives them no presumptive force. It may say, This will happen unless a court considers that something else is more appropriate. So that's a little bit sticky, but not very sticky. At the other end of the spectrum, you've got laws like New Zealand's relationship property regime, which provides for equal division and then says you can depart from that if there are exceptional circumstances which mean that equal division would be repugnant to justice. So that's a super sticky default, right? You've got to come up with exceptional circumstances that are repugnant to justice. And if you think about what most people need to understand about the law as a result, for almost everyone, all they need to understand is that generally the rules equal division. And you will not get many cases where there is any argument about that, as compared with the situation where, for example, you say that the division must be fair and reasonable. Lots of room for arguing about what factors might influence that. And what might drop out. You'd get very different practical outcomes. Making compliance a default is also, as in a default outcome, also works well, rather than leaving it to people to work out how much tax they should pay, put it to one side and then remember to send it in every now and then to the tax department. You make compliance a default by having tax deductions at source by employers who are better placed to manage the complexity, by financial institutions who deduct withholding payments. And tailored defaults, and technology is going to let us do more and more of this, I think, defaults that are not one size fits all, but different sizes to fit different circumstances based on information provided. So we have in New Zealand's child support legislation what we call a formula assessment, which is a first rough cut at what a parent who is liable to pay child support must pay to the parent caring for the child. And it's quite a complicated formula. There's about 14 variables. You plug them all in, a number drops out. And that is the amount of child support that must be paid unless and until a review decision varies it. So you get an immediate preliminary binding determination under which some money flows. You don't have to go to a court to determine what amount should be paid before anything flows. And then you can go to an official who reviews it by reference to certain criteria, or you can ultimately go to a family court judge who can basically do whatever is just in the circumstances. But it turns out the vast majority of people stop at the default. Construction contract adjudication is another great example of this, but we haven't got time to talk about it. Safe harbour provisions that treat compliance with more precisely defined requirements. The light's going out. It might be some sort of hint, I suppose. But as long as there's still people here. Safe harbour provisions that treat compliance with more precisely defined requirements as a method of compliance with the general standard. We see this in a lot of performance-based regulation. For example, performance-based regulation of buildings that have to meet certain standards for durability, for fire safety, for weather tightness, coupled in many regimes with acceptable solutions issued by a regulator that say, well, if you use these materials and these techniques, you will be treated as complying. It dramatically reduces complexity. Preliminary rulings and clearances, detailed requirements instead of a general standard, coupled with help to navigate them, which of course technology makes easier than ever before. If I had time, I would do my favorite rant about if JB Hi-Fi can give you effective tools for searching for the stereo that's relevant to your uses and for comparing different options. Why can't we do that with hazardous substances regulation? Just have to probably be grateful you've been spared that, actually. Licensing regimes that translate general standards into the requirements for a specific entity, very common in relation to banking and insurance, for example. Agency guidance on requirements, which may either just be helpful information about what's required in a more accessible form, or may be relevant to assessment of compliance or to penalties for non-compliance. As you give it more and more force, it starts to look more and more like a safe harbour provision, but you can graduate that. Accessible, timely, user-friendly interfaces. Think of my variable speed sign. So in the time available, let's just talk briefly about how we fixed the problems with my buyback provision. In 2008, and I was also involved in this process, it was amended. And the purpose of this slide is mostly to show that I am a legally trained person who puts too many words on a PowerPoint slide, which is a legal skill. But basically what it says is the buyout price must be a fair and reasonable price, so still my test, right, as at a particular date, calculated as follows. And then what it says is you take the value of the company as a whole. Most companies only have one class of shares. You take the company as a whole and you do a pro rata value. And that's what you get. And in doing that in doing the valuation of the company as a whole, you disregard the proposal that triggered the buyout right. So, and then you have subsection 3. However, a different methodology from that set out in paragraphs A to C may be used to calculate the fair and reasonable price if using the methodology set out in those paragraphs would be clearly unfair to the shareholder or the company. So there's a default, which is pro rata value, and that is indeed appropriate in the vast majority of cases, and it's been made slightly sticky. You can't just depart from it because it seems like a good idea. It has to be clearly unfair. There needs to be a reasonable margin of unfairness. And the litigation basically disappeared. This was enough of a clarification of the complex general standard to make a very material difference to the operation of the law in practice. Okay, very quickly, technology. We have more options for reducing complexity at our disposal today than any other generation of legal designers has had. Technology can provide a complexity reducing interface. It can provide answers to questions like how will the people affected by legislation be made aware that it exists and of its relevance. You can provide information and you can provide user interfaces. For example, simple tools like tools to locate relevant requirements, especially in complex regimes, automatic reminders of periodic requirements, very effective to send people reminders in advance of an obligation to file a tax return, an obligation to file a company return, online interfaces to renew licenses and passports, online forms to engage with government, and you can pre-fill them wherever possible. So dramatic improvement in compliance with annual return requirements in various legislation in New Zealand, where we started sending people forms pre-filled with the last information they sent out, and they can either just confirm it's still accurate or change the things that have changed, but they don't need to fill the whole thing in again. People mostly will comply with the requirements if you make it easier rather than harder to do so. One of the problems with a lot of the legislation we design is that we put unnecessary and avoidable barriers in the way of people who are willing to do the right thing as long as it's not unreasonably difficult. The same, of course, applies to benefits, accessing benefits, and even more so. If you want to get some benefits out there, but you make it really hard to access them, really complex to access them, those benefits are not going to be enjoyed by the whole universe of people that you hoped would do so. Online calculators, real-time provision of relevant information, and yes, I am going faster and faster as I go over time. That's a really bad habit I should learn from, consistent with mum's instructions, right? Learn from the failures, learn from the mistakes. And then there are more sophisticated mechanisms. I've talked about child support formula assessment, and I think I should skip over the company name approval example, fun though it is, it's in the book. Anyone who's desperate to know about it will just have to buy it. That wasn't deliberate, but it worked, right? So, that brings me to my conclusion. Christine will be extremely relieved to hear. It seems to me that we should take seriously the concerns I identified in relation to complexity of laws. There are fundamental reasons of principle and compelling practical reasons to try to avoid avoidable, unnecessary complexity. We should strive for the greatest level of accessibility and predictability for people affected by a law that's reasonably achievable. We should minimize complexity of obtaining benefits under law, of complying with law so far as possible, and make it as easy as possible for people to do the right thing. That may involve more complexity on the page, indeed often because you have to legislate for the machinery, the institutions, the interfaces that will result in your indirect communication being more effective. Think of the land transport legislation. You will end up with more complexity on the page in order to reduce complexity for your ultimate audience. And that, it seems to me, is a good thing because it's the user experience that does matter most for the rule of law, and for the effectiveness, for the success or failure of the legislation. And if we get that right, then that also, of course, reduces the prospect that your legal design project will be subject to further autopsies in future editions of my book. I'd be delighted to answer any questions that anyone may have following that rather swift scamper through my overly long slides. Christine.
Thank you very much to Justice Goddard for that elegant and accessible, sophisticated, and definitely not confusingly complex talk. And there were no damp squibs or nasty surprises in sight. So thank you very much for sharing the lecture with us. And I'll remind people that there is a book, Making Laws That Work, from Hart Publishing. And thank all of you for coming to this event this evening. And you're very welcome to stay for a bit longer and network with each other, and there's still some catering there to enjoy. So thank you, everybody.